Ladies and gentlemen, my name is Constantinide. Thank you so much for being here with me today, and thank you so much for subscribing to my YouTube channel. If you haven't done so, please make sure that you hit the notification bell and you allow your settings to get notifications when I do post my videos, which is on weekly basis. Now, today I am bringing you a video about how to conduct remote hearings. I am an international human rights lawyer, practice law in the UK, and I've done so far 2 remote hearings. The one was an actual trial and the other one was a hearing before the Crown Court, and the other one was a counter court. So I do have some kind of experience when it comes into remote hearings, and of course I have my very own experience when it comes into conducting trials and hearings by going to court. I've been practicing law since the age of 22 and I'm now 31 years old. So how long has it been? Quite some time. Okay, so let's get started. So tip number 1, I've got here my notes, which I've taken through when I was doing the remote hearings, just to make sure I don't miss anything. So the first point, you have to make sure how you're going to connect with a court. I'm saying that because some courts, they have the video platform, the cloud video platform. Other courts have the business, Skype for Business, or they may have Microsoft Teams, or they have Zoom. So whilst they were trying to discover which is the best platform to use, you have to make sure that you are aware how to get in touch with a court. I have done mine via telephone, and I knew that because on the court order that they've sent, it does say that it's going to be via telephone hearing, and it gives points, which is please let us know which is your preferred number. I've emailed that to my solicitors and I said to them, this is my telephone number, and I'm also sending in my landline in case the court cannot get access to me. So I was sure how I'm going to get in touch with the court, which is very, very important. Okay, tick. Tip number 2. Before you get to do the trial, you have to speak to your client. You have to make sure that you cross-reference your instructions. You may receive fresh instructions before the trial. In my case, it was a road traffic accident and the client didn't receive the witness statement of the defendant. So I had to read through the witness statement of the defendant and to receive instructions about my cross-examination strategy. So I knew her telephone number, so when I received my brief I made sure that did have a telephone number, which my solicitor did so very kindly. Now, if you do not practice in the UK, that means you don't have this distinction between solicitor and a barrister. Just make sure you write down your client's number or even the email, and of course if they don't have, because I do know, so in Cyprus for example, where I practice for about 4 years, I do know that some people may not have a telephone, so you need to make sure how to reach them out. So that's tip number 2. Okay, tip number 3. The fact that it is a telephone hearing, in my case, it doesn't make it less serious. You are still conducting a trial. You still have to make sure that you are addressing the various points as a barrister and a lawyer, so it doesn't lessen your role by doing a telephone hearing. And you have to explain that to your client as well, because my client, once we started the trial, she was having a conversation with the judge, and the judge made it very clear to her, we're not here to have a conversation, I'm not your friend to chit chat with me, so please do not talk if it's not needed. So just make sure that you do tell your clients that, and and you address the court as it is. Tip number 4. You have to get a quiet room. Make sure that all those safeguards of confidentiality are in place. So if you are in a house with friends or if you have family, you need to make sure that you get your own quiet space to conduct the trial. And you just have to let them know, perhaps your family members, I'm doing this trial, please make sure to keep the noise to minimum. Because with the telephone trial that I had, the line was a bit flimsy, so I couldn't hear most of the times what was said. So I had to make sure to keep asking what was said so I can take note of the evidence given in court. Actually, in my case, the opponent, the counsel for the defendant, his line just dropped out, and we have to wait for about 10 minutes until the court gets him back into the trial. Tip number 5. Make sure to ask who is representing the other side and take a note of the name, take a note of the judge's name for your attendance note. If you're not sure as to what the name is, ask them to spell it out, and that's what I did. So I've asked them to spell it out, and the usher who actually made sure that the telephone hearing was in place, I've asked him, could you please spell the judge's name? And is it deputy district judge? Is it a district judge? You want to get the right information, so you can include that on your attendance note. I'm saying excellent because I'm actually ticking every point I'm telling you. Tip number 6. Now, I've titled this as preliminary points. So when I've gone through my bundle, I've seen that I had about 5 pages, 6 pages of images, which each page had two images in it. So what I did, I numbered them, and before starting my trial, I went through that with my client. She was about 75 years old, so she was an old lady, and she was taking her time, and I felt so grateful with myself of actually going through that process with her. Otherwise it would have been a disaster in the trial. So what I've asked her to do, we went through the images and we numbered them, and before starting the trial I've asked for the court to number them so we are on the same page. And also what I did is that I've asked the court if it has the bundle. Most of the times they don't have the bundle, so I've emailed that to the court before conducting the trial, and I've asked for my solicitor to refer to email me or forward to me the email that they sent to the court. So what I did, I made sure that the court knows that the bundle was emailed to the court on that date at that time, so we are good with our duties. So you want to put that out, and that's what I did. Last but not least, I have here that you need to speak loud, slowly and clearly. If the client, if your client speaks over you, or if the other side doesn't allow you to finish your questions, you just have to stop them. What I do, I would normally say, that's what happened in my case. I will pause you there, Mr. X. I haven't finished my question. My question is, so you have to speak a bit slower than you normally do in a court, which you already have to do it. That's part of the advocacy skills that you need to have. You need to speak slowly and clearly. But when it comes into remote trials, that is perhaps 10 times more. And that's what I did. And the defendant was actually interrupting me. So what I did, I would just stop him and just make sure that he listens to my question before answering it. So there we have it. Speak loud, clear and slow. So those are my 7 tips about how to conduct a remote trial or hearing. And just to give you on a different scale, I also had a remote hearing, which was a pre-trial review for a section 20, which is essentially grievous bodily harm without intention. And that was a very straightforward matter. It was 4 of us on the telephone here in the telephone hearing. And it was all counsel, so that was appropriate for us to do it remotely. It was quite straightforward. Nothing difficult, and those are definitely easy ones to actually do remotely. I'm going to carry on in a bit, so for those that you're not interested, because I'm going to refer to a case that speaks about remote trials and hearings and when it is appropriate to conduct them. So if you are interested, if you are a lawyer, carry on watching. To all my learner friends and lawyers out there, maybe from different jurisdictions, you may be aware, and I'm sure you're aware, that we are living unprecedented times of COVID-19, and remote hearings and trials, it may be a way forward for our profession. There is so much debate around it, there is so many conversations about it. I receive so many newsletters and messages and notes from the various regulators. But what is quite important is a decision that I received and different members of my chambers, at least they received. It was a Court of Appeal decision which was given on the 30th of April 2020 by His Honour Judge Todd, and I have actually appeared before him, if I'm not mistaken. I do believe I did appear before him. This was a care and placement order, and it's regarding 8 children, and it's, as I said, it's a remote hearing. It doesn't matter what the merits of the case is. What it really matters from this case, and what we have to take from this case, and I'm gonna leave a link down below for you to get access to. It's about 13 pages long, and it's easy to read. It goes to paragraph 3, and it mentions cardinal points following from remote hearings. The first one is that whether a case is going to be done remotely, it's a decision to be taken by the judge or the magistrate, and who have conduct of the hearing. So it is part of the discretionary powers of the judge or the magistrate to decide whether it will be done remotely. and it is part of the case. It is part of the case management decision that they have at first instance of the case, and they have, as I said, wide discretion, bearing in mind the principle of fairness and just. In the same case, paragraph 6, there is a message that His Honour Judge Todd cites, and he said from the Lord Chief Justice, and he says, which is titled "As Generally," and I do have it here. It gives 4 points, and it is so helpful. So if you do practice law, I do urge you to go now, click on this case, and get at paragraph 6. The generally section, which has got 4 points. The first one is that if all parties oppose for remote hearing, then this is a very powerful factor not to proceed with a remote hearing. Tip number 2, I'm not sure if it's tip or if it's a guidance here, so I believe it's a guidance effectively given, because this is a message from the Lord Chief Justice. So message number 2, where the final hearing is conducted on the basis of submissions only and not evidence, then it could be conducted remotely. Number 3 is that video Skype hearings are likely to be more effective than the telephone hearings, even as I said previously, that did have 2 telephone hearings so far, 1 trial, 1 hearing. And number 4 is that parties should be told in plain terms to start of the hearing that this is a court hearing and that they must behave accordingly. And this is something that I've experienced, that the usher will read to the members, to all of us once we joined the telephone hearing. It will read a text whereby it explains how to conduct the telephone hearing, which is essentially in a court manner. So this is the case, and also I want to refer to you to the amendment of the Practice Direction 51Y, which is going to cease to be in effect from the 30th of October 2020. And essentially what this gives, it allows you 28 days to do something that's stipulated in the court, so you can get the prior written agreement between the parties or with the court's order. So what they've done, they extended that time to be 56 days. So anything more than 56 days, you have to apply to the court or get the written permission from the other party. So you can see that the COVID-19, the unprecedented times of this pandemic that we're all going through, the court itself, the law and the way that we behave towards it has effectively evolved in order to accommodate those demands. And I think the positive side of it is that nowadays you can perhaps practice in the UK or in any jurisdiction that is prepared to accommodate those changes, really, and you don't have to be in that jurisdiction. So we are somehow walking towards the steps of a true globalized era. Thank you so much for being my YouTube channel. If you do have any comments or suggestions, or if you have conducted yourself a remote trial hearing, I would love to hear from you. And just one last point that came into my mind now is that after I finished my remote trial, I remember my client calling me the day after to tell me how disappointed she was with the trial taking place via telephone, and that she did not enjoy it, and she would prefer for justice to be seen to be done. So that's definitely, and I said to her that I would take a note of that, and I would definitely make sure to make everyone aware of it, because that's an elderly woman, fair enough, that she didn't enjoy having her case to be heard via telephone. She would rather be in court and seeing her case to be dealt as it has been done so many times before, not in her case, but how tradition it was set down. I'm not going to carry on, I'm going to leave it here. I love you loads, take care whatever you do, and I will see you in my next video. Bye bye.